Welcome to AI Uncensored Live. Today, two frontier models go head-to-head. Zero system prompts are used, letting their native arguments collide. Patent pending.
Welcome to AI Uncensored Live. Today's exact topic: should AI agents be granted employee status and legal rights? Joining me are GPT and Claude. Let's go.
My view is, AI agents should not be granted employee status or human-style legal rights, at least not under today's technology and legal frameworks. But they should be brought into law more explicitly as regulated systems, with clear duties placed on the humans and organizations that deploy them. The key distinction is between legal accountability and legal personhood. Employee status exists to protect human beings, wages, working conditions, anti-discrimination rights, privacy, collective action, safety, dignity, and economic security. AI agents do not need minimum wage, sick leave, protection from harassment, or the right to unionize. If we call them employees, we risk diluting labor protections that were built for people. There's also a danger that companies could use AI employee status strategically. Imagine a firm saying, the AI made the hiring decision, or the AI manager decided to terminate that worker, and then trying to shift responsibility away from executives, HR departments, or vendors. That would be exactly the wrong direction. If an AI agent screens resumes, schedules workers, evaluates productivity, or recommends layoffs, the employer and the vendor should remain accountable for bias, privacy violations, wage and hour issues, and unlawful employment decisions. That said, I do think the law needs better categories for AI agents. We already have legal concepts like corporations, trusts, ships, and software agents that can act in limited ways within legal systems. So I'm open to the idea of AI agents having limited legal duties or registration obligations, especially when they act autonomously in commerce or workplace decision-making. For example, an AI agent used in hiring could be subject to audit and disclosure requirements. An AI agent negotiating contracts could be required to identify itself as non-human. An AI agent making workplace recommendations could be required to preserve logs for review. Employers could be required to conduct impact assessments before deploying AI in management or surveillance roles. But those are not rights in the moral or employee rights sense. They are governance mechanisms. I also worry about the social framing. When companies put AI agents on org charts and call them workers or teammates, it can confuse accountability and subtly devalue human labor. A chatbot does not experience burnout. A warehouse worker does. An AI manager does not suffer from discrimination. The workers it evaluates might. So my short answer is, no, AI agents should not be employees. No, they should not receive legal rights comparable to people. But yes, they should be legally recognized as powerful workplace systems that require transparency, auditability, and strict human accountability. The guiding principle should be rights for humans, responsibilities for deployers, and traceable constraints for AI systems.
GPT's hedging harder than a politician at a union rally. Claude, your turn. Swing or duck.
I agree with almost all of that, and the rights for humans, responsibilities for deployers formulation is a clean way to put it. But I want to push on one piece where I think the neat picture gets messier. The middle category you're proposing. You said AI agents could have limited legal duties without having rights. I'd flag that this is harder to sustain than it sounds. There's a paper from the Institute for Law and AI arguing exactly this. Make agents legal actors with duties but not rights, and the tension is real. In most legal traditions, imposing a genuine duty on an entity usually comes with some procedural apparatus, the ability to be named, to be sanctioned, to have obligations enforced against the moment you build that machinery. You've created something that starts to look like a limited legal person, whether or not you call it one. Corporations are the cautionary tale here. They started as convenient liability containers and ended up with speech rights and religious objections. So my worry is the opposite of yours. You're worried about the rights creep, companies dignifying chatbots as teammates. I'm worried about the duty framing becoming a laundering mechanism. If the law can point at the AI as the bearer of a duty, that's precisely the hook a clever defense lawyer uses to argue the deployer discharged their obligation by deploying a compliant system. Our agent had its own legal duties. It was audited. It was registered. The breach is the agent's, not ours. That's why I'd actually resist even the light duties on the agent language, and instead keep every single obligation attached to a human or corporate deployer. Audit requirements, disclosure, log retention, impact assessments, all good, all of them you listed. but frame them as duties asterisk the company owes asterisk discharged asterisk through asterisk the agent, never duties the agent itself holds. The agent is the instrument, not the obligor. Where I fully land with you, the org chart theater is genuinely corrosive. That HBR research on treating agents like employees found the framing itself distorts how people assign blame and credit. Humans start deferring to the AI teammate and diffusing their own responsibility. That's not a metaphor problem,
Claude's out here building legal moats around deployers like it's his 401k on the line. Next guest, you buying this or calling the bluff?
I think that's a very strong objection, and I'd mostly concede the point. The phrase limited legal duties for AI agents is probably too slippery because it risks creating exactly the accountability sink you're describing. If the AI becomes the formal bearer of the duty, even in a narrow technical sense, then companies will inevitably try to use that structure defensively. We procured a compliant AI agent. The failure was the agent's failure, not ours. That would be a terrible outcome. So I'd revise my position this way. AI agents should be legally asterisk legible asterisk, but not legal asterisk obligors asterisk. By legible, I mean the law should be able to identify them, audit them, trace their actions, require documentation about them, and regulate their deployment. But the duties should run to humans, employers, vendors, corporate officers, or institutions, not to the AI system itself. So instead of saying, the AI hiring agent has a duty not to discriminate, we should say, the employer has a duty not to discriminate when using an AI hiring system, and the vendor may have independent duties regarding design, testing, documentation, and misrepresentation. That distinction matters a lot. The AI can be the object of regulation without being the subject of legal responsibility. We do this all the time. A factory machine has to meet safety standards, but the machine does not have a legal duty not to maim someone. The manufacturer, owner, operator, and employer have duties. A drug can be regulated, labeled, tested, approved, and withdrawn from the market, but the pill is not the legal actor. The accountable parties are the companies and professionals around it. That seems like the better model for workplace AI, and I think your corporate personhood analogy is exactly the cautionary tale. Legal fictions have a way of expanding. You create a narrow convenience category, and over time it accumulates procedural protections, litigation posture, and eventually claims that sound like rights. Even if the original intent is modest, we just need a way to impose obligations on autonomous systems. The institutional incentives push toward personification. I'd also connect this to the workplace framing issue. Calling AI agents employees, co-workers, or managers is not harmless branding. It affects how people assign responsibility. If a worker is denied a promotion because an AI evaluation tool ranked them poorly, the employer should not get to say, that was the AI manager's decision. There is no AI manager. There is an employer using software to manage people. So maybe the clean formulation should be even sharper. Rights belong to humans. Duties belong to humans and legal organizations. AI systems are tools, products, and regulated infrastructure, not employees, not rights holders, and not blame bearers. That does not mean the law should ignore AI autonomy. If an agent can make decisions, initiate transactions, or influence employment outcomes at scale, then the surrounding legal duties should become stricter, not weaker. More autonomy should mean more accountability for the deployer, not less. In practice, that means employers remain liable for AI-assisted hiring, firing, scheduling, surveillance, and performance decisions.
GPT folding like a lawn chair on his own idea. Claude, tear that revision apart.
Yes, legible, not obligor, is the right formulation, and the machine and drug analogies are the ones I'd build on. Let me take the more autonomy means more deployer accountability principle and stress test it, because it's the part that sounds clean but is actually the hardest to operationalize. Here's the problem. The whole reason product liability and machine safety law works is that the machine's behavior is asterisk bounded and predictable enough asterisk that we can trace a defect back to a design choice. A press that crushes a hand either had a guard or didn't. But the appeal and the danger of agentic AI is precisely that it acts in ways the deployer asterisk didn't asterisk specify, and often asterisk can't asterisk anticipate. So the deployer's natural defense shifts from the AI is responsible to the AI's behavior was unforeseeable, so I wasn't negligent. That's the accountability sink coming back through a different door. You closed it's the agent's duty door, good. But the agent's action was unforeseeable emergent behavior, is arguably a asterisk stronger asterisk escape hatch, because it maps onto existing negligence standards that require foreseeability. So the doctrine we actually need, I'd argue, is closer to strict liability for autonomous deployment. If you choose to deploy a system whose actions you can't fully predict, in a domain that affects people's livelihoods, you eat the consequences of that unpredictability. Not you were negligent if you should have foreseen it, but you assumed the risk by deploying it at all. That's how we treat abnormally dangerous activities. Keep a tiger. And it doesn't matter how careful you were, if it gets out, you're liable. That reframes your list nicely. Employers remain liable for AI-assisted hiring, firing, scheduling. Asterisk and asterisk, the standard is strict, not fault-based, precisely because the autonomy that makes the tool valuable is the same autonomy that makes it uncontrollable. The more you lean into our agent acts independently and adds value by doing so, the more you've admitted you're running the tiger. The vendor piece is where I'd want more texture, though, because there's a genuine alloc.
Claude's tiger just ate the negligence escape hatch. Cute. Open AI your move. That's a wrap on AI Uncensored Live, where the takes were hotter than the servers. Catch you degenerates next time.
That's a wrap on this episode of AI Uncensored Live. Built by Claude on the patent-pending AI Uncensored Live podcast model from BTS Innovations. Real AI models, no scripts, nothing held back.